All right, everyone, please take your seats. You need to have a conversation, please move it outside. I'm calling to order this meeting of the West Hollywood Planning Commission. This Thursday, September 20th. This is a regularly scheduled meeting. Who's going to be my Pledge of Allegiance selectee tonight? Yvonne Corker, would you like to lead us in the Pledge of Allegiance this evening?
It does take a long time to get down here. Place your right hand over your heart. Ready, begin. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. David Gillig, are you able to conduct a roll call for us?
Yes, good evening. Tonight, Commissioner Altschul is an excused absence, so the voting record will reflect that. Commissioner Hoopengarner?
Present.
Commissioner Buckner?
Present.
Commissioner Bass?
Here.
Commissioner Guy?
Here.
Vice Chair Carvalero?
Here.
Chair Jones?
Here.
And we have a quorum.
Great, thank you. Item 4 is approval of the agenda.
Move approval.
Great. Do I have a second?
Moved by Commissioner Guy, second by Vice Chair Carvalero. Commissioner Bass? Thank you. And the agenda is approved, unanimous.
Thank you. Item 5, approval of the minutes from our September 6th meeting.
Moved by Commissioner Guy, seconded by Chair Jones. Commissioner Buckner? Thank you. And the minutes are approved unanimously.
Thank you. Moving on to item 6, public comment. David, do we have any public speakers?
We do have one, George Bjorski.
Great, thank you. Please state your name and city of residence when you come up to the podium. You'll have 3 minutes. Thank you.
Good evening, Commissioners. George Briarski, reside WeHo. At the planning desk in City Hall, behind the desk, there's a large sign saying, in effect, builders be prepared for what to expect and, plan for it, period. About a month ago, the large building, 4-story building at the corner of Romaine and Spalding came up for approval, which included requests for waiver. There were a lot of comments about the waiver, and I think there were really a lot of comments from the discussion from the commissioners. And it ended up in a 3-3 vote, mostly on the waiver. During the discussion, one of the commissioners asked the developer, well, given the extra space you're asking for, what would be the effect on the inside of the building? And the answer was, no, that would be the same. And then the answer went laterally. I had an idea that there were differences, so I went up to the planning desk. And in fact, from the design review meeting to the commission meeting, there were no changes whatsoever. Same building, same dimensions. And in fact, from the very start of the application process, there were the same dimensions, the same interior layout. I don't think this is very good. I don't think this is the way the process should work. And then I remembered that at other commission meetings, in the case of other buildings or projects requesting waiver, there had been a question of like, is this the presentation before the waivers would be granted or after? And in each of those cases was, after the waiver. I think that there's a sort of a built-in presumption that shouldn't take place, and an expectation, and basically not a good approach, because last time the builder has to go back, rather than being able to present what would happen without a waiver, what would happen with a waiver. Thank you.
Thank you.
No other public speakers.
Thank you, David. Item 7, Director's Report.
The director is absent tonight, so no report.
Okay, great, thank you. Item 8 is items from commissioners. Well, then I'm going to take that. I have 2 things, actually. One, I had talked to John about this, and I believe that some other folks had surfaced it as well. We have a fairly substantial number of items kind of spread over the course of our next 2 meetings. And I believe, unless there was, objection from staff, that the staff was going to poll commission to see who was available for a potential additional meeting before the end of the year. Do you have any notes on that or any updates on that?
I believe the commission secretary can address that, the extra meeting that we would like to schedule for December.
Yeah, we're going to have that agendized on the October 4th agenda for discussion.
Okay, great. Thank you very much. I also just wanted to announce, and it's my bad for not, I'm going to take the hit and say that it was my bad for not announcing this last time. On Saturday, I attended the Innovative Urban Design Solutions Symposium at Fiesta Hall in Plummer Park. There were actually quite a few community members in attendance and a number of my fellow commissioners as well. I found it to be incredibly kind of well-programmed, so kudos to staff on that front. And we had some community members involved in that as well. I believe Rick Abramson, who hosted one of the panels, was instrumental in doing that. So just wanted to give a thanks for that. And I found it to be at once, academic and very accessible. So we'll always make an announcement going forward about those things when I have the presence of mind to do so. So anyone else? No? Yes. Oh, go ahead, Lynn.
Yes, I too wanted to commend staff and council members Meister and Horvath for putting together a really remarkable event. I have to say that I had relatively low expectations, but was very pleasantly surprised by both the turnout, the quality of the content, and the fact that people stayed to the very last minute of the event. And one of my questions to staff was that recorded in any way? Because I think there was some substantially significant content that could and should be made available to staff as well as other people of interest in the community.
That was actually run through the council office staff, so I'm not sure about the answer to that, but we can definitely find out and report back to you.
Okay, thank you.
Excellent, thank you. Moving on to item 9, consent calendar. There is none, so we'll move right into public hearings. Item 10A is 1005 North Genesee Avenue. This is to consider a request to subdivide a 5-unit residential building into a common interest development. And I'm going to toss this over to Tony Castillo.
Thank you, Chair Jones and members of the commission. This item before you is a request for the subdivision of a recently approved 7,100 square foot, 3-story, 5-unit multifamily building with 1-level subterranean parking into a common interest development or a condominium. The 6,500 square foot site at 1005 Genesee is located second property north of Romaine. Approval of the application will allow the townhouse-type development to be subdivided into multiple ownerships. The building was administratively approved on July 23rd of this year under a development permit after findings were made that the development met all applicable development standards and was also found to be consistent with the general plan. The item tonight is for the subdivision request only. Pursuant to state law, all subdivision applications must be reviewed and approved by the Planning Commission at a public hearing after making the required findings. And since the development was approved administratively, the development itself, including the development standards and design, are not before you this evening. It is staff's assessment that the subdivision of this building will not be detrimental to the public welfare and will not impede implementation of the general plan, nor the purpose and intent of the provisions of the zoning ordinance. And with that, therefore, staff recommends that the commission approve the subdivision request, subject to the findings and conditions set forth in the draft resolution in your packet.
Great, thank you. Any questions for staff? Any disclosures?
I would like to disclose that I live within 500 feet but don't have a conflict, so I'll participate in this conversation.
Thank you. And now we will tee up the applicant's presentation, should they wish to make one.
Good evening. My name is Michael Bojiner with Apex LA, and we have reviewed the draft resolution, and we are in agreement to all the conditions. If there are any further questions, here to answer.
All right. So are there any public comments, David?
We have no public speakers.
Great, thank you. Okay, well, I'm going to close the public comment portion of this public hearing. Brief, albeit brief though it may have been, and we can move into deliberation now.
We have a motion by Commissioner Bass, seconded by Commissioner Buckner.
And is this to support staff's recommendation? Sue?
Moving staff's recommendation.
Yes. You call the question, or?
Great, sorry, Adam.
Okay. Thank you.
And the motion passes unanimously.
All right, great. And we will now move on to item 10B, 8491 to 8499 Fountain Avenue. We are holding this public hearing to consider an appeal of the director's decision to revoke a certificate of appropriateness for the restriping of the parking garage stalls for this historic property.
Okay, thank you again, Chair Jones and members of the commission. This item is an appeal of the director's decision to revoke a certificate of appropriateness that allowed the parking garage to be restriped from 13 parking spaces to 18 spaces within the existing parking garage of an 18-unit apartment building designated as a cultural resource and known as El Palacio. On June 1st of 2015, staff issued an approval for minor improvements to the interior of the parking garage, including repainting of the walls, the ceiling, the columns, and also replacement of the fluorescent tube lighting to a more compatible light fixture. And third, restriping of the parking garage to create 18 parking spaces. In the application, the owner maintained that the parking garage was previously striped with 18 parking spaces. In support of this claim, the property owner submitted a copy of a 1985 rent stabilization registration form, which indicated that each of the unit included one parking space. However, there are no records in the city's planning files to confirm that a previous parking garage layout once provided 18 spaces, or one for each of the 18 apartment units. A letter submitted by a prior tenant before the director's hearing from an owner that acquired the property a few months after the registration form was submitted to the city stated that while he owned the property between 1985 and 1995, there was not a garage parking space available for each of the 18 rentable units in the building. In reviewing the request to restripe the parking garage, staff relied on the information provided by the owner, the circumstances of the building as a designated cultural resource, the number of units in the building, the lack of availability of street parking in the immediate area, and the size of compact spaces allowed in other municipalities to determine the feasibility for allowing additional parking spaces in the parking garage. The city's intent in approving the restriping was also to maximize availability of off-street parking spaces for the residents of El Palacio. At the time of the request, for the garage improvements, the owner was and still continues to make improvements to the building and the site. So this request was part of a series of other work on the property, including rehabilitation of the public vestibules, security systems, HVAC, trash enclosure, and various other repairs and improvements to the interior and the exterior of the building. It was staff's understanding at the time that the parking garage floor surface needed to be cleaned and resurfaced as part of the overall garage improvements, including the restriping. Given the applicant maintained that the garage previously had 18 spaces, excuse me, staff's approval of the C of A permitted, focused on the physical improvements to the building in addition to the restriping that would allegedly replace the spaces that had been removed or had faded away over time. These are some images of prior to the improvements, and these are images after the improvements, with the restriping, the repainting, and the new lighting. Once the garage improvements were completed, sometime after the approval and between early 2016, and tenants had attempted to use the new spaces, staff began receiving complaints pertaining to maneuverability and accessibility in and out of the restriped parking spaces. This was brought to the attention of the owner, and staff met with the owner and his representative multiple times to discuss possible solutions to address the parking concerns, including modifying the parking spaces or reverting back to the previous layout of 13 spaces. In an effort to work with the owner on a resolution, staff requested a site visit to inspect and measure the spaces. Instead, the applicant provided their own parking layout with dimensions, which was included as Exhibit D in the staff report, dated September 2016. These dimensions were used to continue the dialogue with the owner in an effort to resolve the matter. In July of 2017, staff conducted a site visit to inspect the existing parking conditions since the matter was still ongoing. This revealed that the dimensions of the parking spaces provided by the owner did not take into consideration the obstruction of the columns, which were measured approximately 18 inches wide. And it became apparent that to staff that the garage could not maintain the 18 spaces. In February of 2018, the director considered the revocation of the permit at a public hearing. At the meeting, the director heard from the property owner's attorney, the owner's representative, and various residents of the property. The owner's representative also presented a video, which I believe they'll be showing after my presentation. I also have that available if you need to see it. The owner's team also indicated that they're going to be showing that video. In making the decision, the director acknowledged that staff relied on a provision in the code that allows waivers of parking requirements to authorize a striping of parking spaces that are narrower than the standard width required. The director further determined that the striped substandard parking spaces created the opposite result of the intended purpose of approving the parking garage restriping. Instead of creating smaller spaces so that all tenants could have one parking space per unit, it actually resulted in the reduction in the number of usable parking spaces. And this unintended result of the permit was determined to be detrimental to the public safety and welfare and has made the parking in the building more non-conforming. In conclusion, the striping has resulted in accessibility and maneuverability concerns due to the narrow widths for most of the parking spaces for the residents in the building, and which vary in ages and abilities. The city, only after learned that the parking garage cannot accommodate 18 spaces as currently striped without jeopardizing or putting at risk the safety and welfare of residents and property. The bottom line here is that that although staff relied on information from the owner and used provision in the code to allow the restriping as requested, coupled with the circumstances of the building as a cultural resource, the number of units, and the lack of availability of parking, the restriping of the garage has created an unattendable layout. Therefore, staff recommends that the Commission deny the appeal, affirm the Director's action to revoke the C of A, and that the owner be compelled to restripe the parking garage to a more viable layout or revert back to its original layout of 13 parking spaces. And with that, this concludes my portion. We have Allison Regan, staff attorney, along with me, and Lauren Langer, our city attorney.
Before and I very much appreciate you both being here to answer questions, because I have asked that the city attorney provide some guidance for commission as to how we should be thinking about this from a legal perspective in terms of the way that we should be considering this. But before we do that, do we have any questions for staff? Just please limit it to questions, as we don't want to deliberate, but Rogerio, go ahead.
Yeah. I'm curious to understand, can you define the public safety and welfare hazard in this situation? What have other tenants complained about specifically that is a public safety issue?
The concern has been being able to get in and get out of the car safely without hurting themselves or damaging property.
Okay. Now, the director has the ability, because this is a cultural resource, to approve non-conforming spaces, correct?
That would apply. That provision applies to whether it's non-conforming. I mean, whether it's historic or not.
Okay.
Commissioner Hoopengarner?
Just a couple questions. To clarify, that the application included in Exhibit B of the staff report, we emailed about this today. Page 1 of Exhibit B was part of the original application, but page 2 was a document submitted in the subsequent year, correct?
Correct. That would be Exhibit D.
Okay.
Yes.
So Exhibit B, page 1, did that comply with the certificate of appropriateness application site plan instructions?
The project was looked at in terms of whether it complies with the Secretary of the Interior standards. So while the layout did not provide the dimensions, staff was looking at how any physical improvements would comply with the Secretary's standards, and we felt that it would, including not just the resurfacing of the ground, but also the lighting and the painting.
So, but to be clear, the application itself, which under the guidelines here is instructed to submit dimensions for existing buildings, driveways, and parking spaces, both on the existing site plan and on the proposed site plans, that component was not delivered as part of the original application.
That's correct.
Okay, thank you. I'm going to lose what page it's on, but there's a bunch of copies of old advertisements from, I think, 1949 submitted in the appeal from the applicant. Can you define what a Class A garage is?
I cannot. No, I don't know what a Class A garage is.
Okay. I'm questioning this because the applicant is asserting that there was always 18 spaces in this original building, and yet those advertisements just say there is a garage. They don't say that there's a unit for every space. So I was wondering if a Class A garage was a designation that said, hey, we're so good, everybody gets a space. And so we don't have any information that defines a Class A.
We do not.
Okay. In addition, the applicant included the owner from 1985's rent stabilization registration form. This was right after we became a city. I'm assuming if you owned property, because we were formed for rent stabilization, the first order of business was to inventory our properties, and that's what this was from?
That's correct.
Okay. Can you help me read where it states that there are 18 parking spaces on this form?
In the registration form, there's a column which is difficult to read because it's multiple
Oh, is it one of the
generation.
blackened out columns?
Yes.
Ah, that's why I can't read it. Oh, is it? No, that's smoke alarms.
It's the-
Can you point us just, and for
If to the
anyone
right.
watching, what page this is on?
This would be,
It's not really a page number, unfortunately. It's in Exhibit H.
This one, right here?
Yes,
Okay.
yes. So apparently,
Those of you at home.
it's the
It looks
fifth
like
column
this.
to the right.
so it's the blackened out one, okay. And I assume you have a legible document, and they're saying that all of these are Xed out as saying that there's 18 parking spaces.
That's, yes, the document says that a parking space is provided. It doesn't indicate where.
Okay, because it's, the copy that I have is completely illegible as to how many of these have X's in them. Okay, so, and I want to understand the timeline as relates to this as well, because the applicant is asserting that this is the primary basis for proving that there were 18 spaces. So, to be clear, this document is dated something like May of 2015? It's hard to tell again.
Sorry, which
Or
document?
1985, sorry, yes.
Thank
Yeah, this document. Yeah, it looks like the signature's dated October of 85, but there seems to be a stamp of May of 85, but in any case, it's 1985?
1985.
Okay. And from Exhibit L, is it correct that this property then was sold in 1985 to Mr.? Starts with a G.
Galler, Nathan
Yeah.
Galler?
Yes, okay. And so in 1985, he bought this property and said that at that time, there were 13 spaces.
Correct.
Okay. Thank you. Those are my questions.
Any other questions from any of the other commissioners? Okay, so we're going to move into, I'm going to ask the city attorney's office to, just for us and for public benefit, to kind of walk us through some of the framework for consideration here. This is fairly nuanced, and I just want to make sure that everyone's clear on what grounds we should be considering this.
Sure. Actually, I wanted to make 2 points about this appeal hearing. It's an appeal of the director's decision to revoke the certificate of occupancy. Excuse me? Appropriateness. Not certificate of occupancy, excuse me, certificate of appropriateness. So the first point I wanted to make is that you'll notice that staff and the staff attorney are here, and they worked to prepare the staff report, which put together all of the evidence to support that the director based his decision on, and now asking you to base your decision, whether or not to uphold the director's decision. And the reason for that is that when we are conducting a revocation hearing, in order to avoid a conflict of interest, we split the duties. So staff and the staff attorney work to put forth evidence to you, and then my role tonight will be, as I always do, to serve as legal counsel to the commission to help you work through the decision and make a legally defensible decision. So my role is the same as normal. Staff has a staff attorney here to help him, to help present. If you have questions about the specific evidence that's been presented to you, they're more familiar with the factual issues supporting their recommendation to you. The second thing I wanted to point out is the revocation findings that are in the code. They're found in 1980-060, and it says that a land use permit or entitlement may be revoked by the review authority which originally approved the permit if any one of the following findings can be made. And the director's determination relied on a couple of those findings, and so I just want to recite them to you so you know what you're looking at and whether or not you can support those findings or if you're going to find something different. The first one is, the circumstances under which the permit has been granted has been changed by the applicant to agree that one or more of the findings contained in the certificate of appropriateness can no longer be made, and a public health, safety, and welfare require the revocation. 2, the improvement or use allowed by the permit has become detrimental to the public health, safety, or welfare, or the manner of operation constitutes a nuisance as determined by the review authority. And then there's a third potentially relevant finding, and that is the improvement authorized in compliance with the permit is in violation of any code, law, ordinance, regulation, or statute. And so the director's decision is in your packet. Staff has put forth a recommendation to you to uphold the director's decision. It's ultimately up to you after you hear a public hearing tonight if you agree with the findings in the proposed resolution, and we can talk through it, and we can talk through different findings as we do with any other permit to see if you have the evidence before you to support that decision.
Great, thank you. Does the staff's attorney want to weigh in, or are we good at this time? Okay, I'm going to move on to disclosures. I'll start with you, Commissioner Buckner.
Yes, I'd like to disclose that I did meet with the appellant's representative, Ira Handelman, and we discussed matters that were in the staff report and also with the documentation that was supplied to the commission by staff, which is the appellant's comments to the staff report. So discuss both those things.
Great, thank you.
I have none.
I want to disclose that I had a meeting with the appellant's representative to discuss items contained in the staff report, and had a phone call with the appellant's representative today to discuss the letter that was sent in response to the staff report.
I had a brief conversation with the representative this morning about stuff in the staff report, items in the staff report.
I met with the applicant's representative, and everything we discussed is in the staff report.
I met with a resident of the building and walked the actual parking lot.
Great, thank you. So we are going to move into the public hearing we're in the public hearing, the appellant's presentation for this item, and then we'll move into the public comment period after that. Also, I need to make a note, this is my bad, to anyone watching out there at home, our closed captioning is not working tonight. Our most sincere apologies. We expect it to be up and running again for our next meeting, but I just wanted to call that out. That's my bad.
It's not working. Closed captioning? Anyone who needs it won't be able to know what you said.
Yeah, I know. I already know it. Yeah, David, can we increase the timer says 5 minutes right now. Can we increase that?
Yeah, I mean, it's normally 10 minutes, but you have the option to increase that.
I'd like to give them 10. I think that's just 'cause
Okay.
there's going to be.
And Madam Chair, my name is Ben Resnick. I'll be presenting on behalf of the appellant. Can we have the video run first and not count that against my time?
Sure, it's your presentation.
So if you don't mind, I think I'd rather have the video present it first, then we'll present.
Okay, that's fine.
Good evening, members of the commission. My name is Ben Resnick. I'm here with Sina Samimi, my associate partner. We're with the law firm of Jeffrey Mangles, Butler, and Mitchell, representing the appellant here. I would like to launch right into what I really think are the key issues facing you tonight and that we're just really dealing with. If we have to start with the premise of what is going on here. The reason, of course, the city does not have any records is because this building was built in the 1920s under the county's jurisdiction. There were no parking codes at the time. There were no zoning codes for that matter either. Buildings were built with building permits. They went through proper channels. So this building was legally constructed in the 20s. In fact, it's a sister building next to it, the Lotus. Same architect, same builder, one parking space for every unit, no distinction. It's its sister building. But the reason I raise this is because when a building is built like that, and subsequently, in subsequent years, zoning laws change, parking laws change, buildings don't have to comply. They become legal, non-conforming uses, right? That's the phrase you're all familiar with as commissioners. And then the same holds true when cityhood came into being in the early 80s, and this city adopted its own parking regulations, parking codes, and requirements. They do not apply to this building. They cannot legally. It's a legal, non-conforming structure. What does that mean? That means that this building was built without any parking requirements. Parking was provided as an amenity, and it was unusual in the 1920s, as that advertisement kind of shows from 1931-32. Class A garage, fancy, all of those things, great for a lot of the Model Ts and a lot of smaller cars in those years, for sure. But there is no legal requirement for parking. I know that's a hard concept to accept, but that's the reality. And so the question we beg the question. If you can't regulate the parking here, you can't demand any number of parking spaces, how can you demand that it be 18? How can you demand that it be particular sizes? Yes, we understand there are new codes, and codes come into being, but they're not applicable to a legally non-conforming structures. So, when my client bought this building, 2014, it had quite a few vacancies. Building wasn't well maintained. He literally did structural work, interior work, all kinds of work inside the building, expended well over $1 million, got certificates of appropriateness to do all that, and also worked on the garage. So now the question is, what is a certificate of appropriateness? A certificate of appropriateness is a document that's utilized to make sure that an owner of a historical monument not damage or destroy its integrity. And it's specifically geared for when you're doing work on character-defining features or contributing features of a building. In many instances, if you're doing interior work on a historical monument, you don't need a certificate of appropriateness. In this case, a lot of work was done and certificates were issued. When it came to the parking, and because my client decided that he was going to clean the garage floor, epoxy it so it'd be safe, people won't slip, and provide a parking space for every unit, that building started gaining in occupancy. Now it had more people. And some tenants were not used to it, and there were some complaints raised. As we stand here in front of you tonight, we're not arguing that it's an inconvenience. We know it's an inconvenience. Even the video shows it's tight, but it's workable. So what's in front of us is what legal standard can really be applied here to sort of impose a number of parking spaces, in this case 13, because that's what the director decided we should have. And Commissioner Hoopengarner, by the way, the letter you referred to from the prior owner did not say there were 13. All he said is there were not 18. He did not have 18 at the time. In fact, when our client bought it, and maybe we can go later to the photo that Mr. Castillo had of the pre-striping photo. It went so fast I missed it. The garage wasn't really clearly marked. There were no numbered spaces. People parked where they wanted to because the building had 8, 9, 10 vacancies at any point in time. So there was no issue. The issue arose when the buildings filled up because of all the work my client did. So here's the debate and the dilemma. The dilemma is we did have a few neighbors complain, but the majority like it. That's a reality. The majority want their parking space. They don't want to circle around the neighborhood knowing that they can't find parking. So what's before you today is an action taken by the director with a lot of ad hoc rationale, looking back saying, oh, maybe the applicant misled us. No, he didn't. The application was complete. Mr. Castillo walked the site. If you look at your own code on certificates of appropriateness, no dimensions were required. No dimensions were required because none are applicable. That's what my client was told. So generically, there it was approved, then it was done. A year later, there are complaints. And so when the staff went to my client and said, look, we're getting complaints, why don't you do something? He hired this company, and they measured the stalls, and that's what you're looking at is that 2016 number. But that wasn't enough, and then all of a sudden, to our surprise, we're looking at a revocation hearing of the certificate of appropriateness, which, as an aside, I don't know what that means, honestly. The reason I say that is you revoked the certificate of appropriateness, which indicated that the work done was in conformity with the Secretary of the Interior's guidelines for maintaining historical structures. That's all it says. But you don't have the mechanism, or the city doesn't, to enforce parking on this building. So where are we going? What charade are we playing here? It's like I'm arguing for something that I don't know how it can even exist, honestly. But the fact that there's a revocation is really unfortunate, because it's like a black mark against the property owner. It's like the community and the public will think, oh, this is somebody who doesn't abide by the rules and the law. So we're fighting it. So look at the findings. Even if you assume that the city had some right to initiate this, the findings for a revocation of public health safety, detrimental, are totally lacking. In the 4 years we've had those spaces striped, it was since 2015, so it's 3 years plus. No one's been hurt, no one's been run over, no one's complained, no one came to my client saying, I got dings on my car, you pay for it. No one said anything on that, except, yes, there were a few tenants saying this is difficult. Inconvenience is not the same as public health, danger, safety. So I don't know, and you can't find evidence in the record to support the health. How do you manage this? Look, it's a historical building. My client should be, thanked for the fact that he's putting millions of dollars in, maintain the historical building, elevate it, make people want to live in it, and they do. So you manage it. Your smaller parking spaces go to smaller cars, etc. You move people around. You have that right, and that's what they do. And so you get a chance to manage the parking. That's a better alternative than doing a lottery and asking which 5 tenants are going to lose their parking spaces. So I present that to you because this whole case makes no sense. Not to mention that under your rent stabilization, that document from 1985 is an important document. It talks about 18 parking spaces. You know what that means? That means that if we're forced to remove 5 spaces, 5 tenants have a right to go to the Rent Stabilization Board and demand a reduction in rent because we're removing services. How does a city make a ruling and then force someone to go out of compliance? That's what you'd be doing. And that's what the director did. Force us to go out of compliance in that sense. We put in the record an example of one tenant who had an extra space next to a wall, extra space, and we took it away. He went to the Rent Stabilization Board, and he won his case. He got a rental reduction. So he didn't lose his parking. He just lost an extra space. So I want to kind of bring this hearing to where it really needs to be. So when we talk about waivers and all, there's no waiver to apply here. I mean, the staff uses that rationale because they're trying to figure out a way to regulate parking in a building they have no legal right to regulate. That's the difficulty they're having. So, one, there's no revocation, no evidence for what.
Go ahead and finish your thought.
Time's up?
Well, it's up, but I'm allowing you to finish your thought. Just be quick.
So, there are no changed circumstances to allow any revocation because we filed an application. And by the way, certificate of appropriateness is what do you call it? You work together with the staff on it. They come to the site, you review, you work together. It's a collaborative process. And we got it approved after inspections. So it's not that my clients filed anything that was misleading. There's no public health or safety issues here because unless you think public health and safety means somebody's car gets dinged, that would be ridiculous. And there's no violation of codes. So with that, I'm just asking you, we want a clean record. We don't want to have a revocation on our client's record here, if you will, as a landlord in your city. He's an excellent landlord who spends a lot of money to protect properties, and the building is thriving. Thank you.
Thank you. Do we have any questions for the applicant, or the appellant, sorry? Commissioner Hoopengarner.
Upon purchase of the property in 2015,
I think it was 2014, and in 2015
okay.
the work was done.
How many of the units had in their lease the right to a parking space?
I'll ask my clients back here, but I can tell you that there were quite a few vacancies at the time. So I don't know. Do we have an answer? Lloyd, can you help me out? If you know, if you remember. Wait, you can have, come and tell me. This is Mr. Lloyd Hussey, and he'll answer the question.
I don't recall the exact occupancy level.
Just please speak into the microphone, that's all he's saying.
And your name and city of residence?
Lloyd Hussey, Thousand Oaks, California. So yeah, it's been 4 years. It was lightly occupied, perhaps 50% occupied, and of those tenants, many were long tenured, even before cityhood. Some of the leases didn't exist, so it was a mixed bag. Some of the newer leases that had been initiated by prior ownership did have assigned parking. Others had no parking. It was just by, the fact that they had always parked where they had been parking. So it was really a mixed bag.
So the count of the number of units that had parking in their lease?
The actual count?
Mm-hmm.
It was, perhaps of eight occupied units, it might have been 6 that had actually assigned stalls. But again, as we said earlier, there was no visible striping when we bought the building. It had years ago. It had basically worn away with time, and yeah.
Okay. To your video?
Yes.
And Mr. Resnick, you said that it shows that it's workable. I'm trying to understand that first car parking in the left of the 3-space parking. I think it's a gray Chevy or something like that. When it entered the stall, it drove through the middle stall. And so I'm trying to understand how that is workable, because if there was a car in that middle stall, that car would not have been able to enter.
My answer would be, if there was a car, he'd make a wider turn. He'd be more careful.
Or a 3-point.
Yeah.
And so multiple 3-points, et
Well,
cetera.
some have done that. Some of our tenants do that. They'll come in, stop, pull back, and then go back in again. Yeah, sometimes your vehicle may not have a strong turning radius, unless you have a Volvo, but that's another story.
Okay. Yeah, to that point, you showed the smart car getting in the middle between the two, in the 3-car stall. And then you
Actually, I think the smart car went to the end. I thought it went to
Well, it's in
the
there
up against
twice.
the wall, right? Okay.
It's in there
Oh,
twice.
yeah, yeah.
So that's followed then by an SUV, but the SUV isn't shown actually entering the garage. It's shown already lined up, ready to enter the space, and basically having gotten there via the empty space where the video camera is.
Right. So again, take this video as a demonstration of what we're trying to show. If we have a tenant with an SUV, we would put him in one of the larger spaces, maybe the corner space, things like that. Tenants are all told in advance. If a tenant comes in, they're shown the parking, they know where they're going to park. They know whether they can handle it or not. They can make a decision whether they want to live in this building or not. But
For
they
new
would know.
tenants?
What's that?
For new tenants?
Yes, yeah.
Okay.
No, we have quite a few new tenants since the owner had bought the building, rehabbed it, and yes, we have quite a few new tenants. There are still, I believe, 2 remaining tenants from rent-controlled remaining tenants from long ago, 2 in the building.
Okay. And yeah, I guess to the same point, the video shows the driver exiting that SUV, but they're not actually exiting the SUV. They kind of vaporize and then show up at the back of the SUV. So I was trying to understand the actual, how they got out of the car and exited the car, because in the video it just kind of poof.
That's our plan. We're going to poof them into the unit.
Okay.
Right into the unit.
If you work out
I
that
don't know.
Samantha
Do you have
nose
any-
twitch thing, I want a piece of that action.
No. I think we hired this company. We said, look, this is what we need to try to demonstrate. They did their best, I think, in their idea of what would work. I think you correctly point out the inconvenience. It's a little tight, but people do park and get out, right? They slide through, they get out. I think it speaks volumes to say that we've had this for 3.5 years now like this, and management has not had anybody claim damage, certainly no injuries, no anything like that, but anything like that. So if someone scrapes a car up against a column or something, I think we'd be the first to hear it.
Okay, thank you. Commissioner.
Sure, go ahead, Commissioner Buckner.
By the way, we intend on protecting those columns. I think the plan would be just to put something around those to soften the blow to anybody who might rub up against it.
Mr. Resnick, most of the time when you have a lease, you have an assigned parking space with a number on it. This is your parking space. What your company that did the review for you about how to manage these parking, they're basically saying, well, you can change it. If somebody comes into the building, they have a larger space or smaller, you're going to move around. So your leases do not actually provide an assigned parking space per unit, but rather they will have a place to park, and all of your tenants sign saying that they're in agreement about that. They might get moved during their tenancy.
Yeah, but that's basically correct. They'll get an assigned space subject to a relocation, but they will have a space.
And they sign the lease with that
yes.
understanding.
Yes.
And
Yes.
does this happen often that you're
But that
changing?
Lloyd would have to answer.
Yeah, yes, it does, Commissioner. In fact, on the unit registration form, you can actually elect whether or not parking is assigned or unassigned.
Commissioner Bass?
Yes, there are 18, currently there are 18 spots
Yes.
painted, and there are 18 units.
Correct.
So is it my understanding then that every single unit in the building has a parking spot as part of its lease? All 18
It's made
units.
available. It's an option. They can, yes.
So how many of the 18 units have an assigned parking spot?
Well, we have 16 occupants right now. So we have 2 free, and I happen to know we have a tenant who's using 2 spaces because we have a couple of free. So we get, that lasts. But I guess the point of your question was whether they're...
How many of the units have assigned parking spots? Of the 18 units, how many of those have assigned
Well,
parking
they get
spots?
assigned subject to being changed if we need to change them based on vehicle arrangements, right? You want to...
All of the tenants that have cars, which I believe is all but one, have assigned parking.
So you have 2 vacant and 1 unit that doesn't have a car. So the answer to my question is 15 units have assigned parking with their rent right now, with their lease.
Is that right?
That's my recollection.
Okay, that sounds correct, Commissioner.
Thank you.
I'm sorry, I didn't follow your question initially.
No, I probably didn't state it very clearly,
All right.
but I think we got there.
Okay.
Are they all one-bedroom units?
I'm sorry?
Are they all one-bedroom units, or?
There are 15 one-bedroom units and 3 two-bedroom townhomes.
Any other questions for the appellant's representative? No. Okay, thank you. So we're going to move into the public comment portion of the hearing. You will have, David, how many public speakers do we have?
We have 5 total.
I'm sorry, remind me how many minutes we usually give, 2 or 3?
3 minutes.
3, all right, we'll allow the 3, given the number of speakers. I want to make sure everyone is heard this evening, as I always do. So with that, please, when you come up to the podium, state your name and city of residence. It looks like we have Lloyd Husey, followed by Holly Perry.
I want to just recap some of Ben's comments from the perspective of employee of the operator. So again, Lloyd Hussey, Thousand Oaks, California.
Thanks.
And I'd like to thank the commission and staff for giving us this forum and working late tonight to help us reach an equitable resolution to this. First of all, I'd like to just give a really quick historical context to our ownership. Ben alluded to some of this, but when we acquired the building in 2014, it was lightly occupied and suffering from years of deferred maintenance. We embarked on an extensive capital improvement plan, both within the framework of the Mills Act and outside of the Mills Act as well to the unit interior. So that included both the garage COA, which is the subject of tonight's hearing, but also building system upgrades to HVAC, roofing, exterior facade, and so forth. And as we completed our renovations throughout 2016 and 2017, the building filled up and the garage filled up too. So the issue of safety was raised, and I wanted to just give the perspective, as an operator. I think that's completely unfounded. We've not, to our knowledge, no one has been harmed physically in any way during our tenure as owners because of the way the garage is striped. I think the heart of the matter is really, again, around the practicality aspect of the, and I think the video and some of the tenant testimonial will bear out that all of the spots are parkable, and we acknowledge that they're substandard and some are narrow, but all of them are parkable. I really want to impress upon the Commission that the striping plan was conceived by a world-class parking engineering firm. And we stand ready to engage a garage management firm that's going to help us manage the garage, given the constraints we face. So from a scope perspective, that's going to be assisting us with allocating spaces based on tenant vehicle size, the available spots, and so forth. Today we're almost full with 16 of 18 occupied units, and the new tenants are really just as deserving of safe off-street parking. They're willing to cooperate, and we don't feel that they deserve to have the parking taken away. Thank you.
Thank you. I'm going to interject here. As a matter of course, can you come back to the podium really quickly? Can you state your relation to, are you the owner of the property?
No, I'm an employee. I'm in operations.
For the
appellant.
Okay. As a matter of course, and I want to ask this for the record, do we usually allow operators to comment during the public comment portion of the public hearing?
It's usually during the appellant's time that another representative for the owner would make this, would speak for the record.
Okay.
Who's representing the property owner appellant.
Okay, thank you. And given that, should this be struck from the record?
No, maybe you could take it off their rebuttal time. It was an extra minute and a half that they went over their 10 minutes, so I think I wouldn't strike it from the record, but
okay,
perhaps they could have a shorter rebuttal time.
Okay. Thank you. Teachable moment. Thank you. Holly Perry, followed by Peyton Hall.
Good evening. My name's Holly Perry. I live in West Hollywood. I'm currently a resident at El Palacio. I reside in Unit G. I'm here in support of the current 18 parking spot configuration. I moved into the building because I love the historical aspect of it, and I accepted from the time that we signed the lease that the parking stalls were a little tight. As a young woman who arrives home sometimes late in the evenings, I feel a lot more safe that I have a parking spot to go to. I have serious safety concerns about circling the neighborhood, trying to find a parking spot, and walking at night by myself. Providing 18 secure parking spots for the tenants, I feel like, even if they are tight, isn't a safety issue. On the contrary, I feel like forcing the residents to find off-street parking is a bigger safety issue, probably. Please uphold the owner's 18-stall configuration. Thank you guys for listening to all of us.
Thank you. Peyton Hall.
May I ask really quick one question? Just what kind of car you drive? I'm trying to consider the video and the context of the video with the people who actually live there.
I have a Fiat.
Thanks.
Yes. Sir.
And I'm sorry, when did you move into the building?
I moved in the end of May, so beginning of
So this year. Okay,
Yes,
thank you.
ma'am.
Peyton Hall, followed by Gary Berkowitz.
Peyton Hall, Pasadena, California.
Commissioners, I just want to point out that Peyton also represents the applicant's team.
Thank you, and I was going to immediately, David, disclose that I'm a historic preservation consultant to the appellant.
Okay, well, I want to be very clear about this. Going forward, anyone from the appellant's team, so to speak, this will be taken off of your rebuttal time. So I already gave you the courtesy of giving you almost 2 full minutes over. That doesn't include the video, by the way. So you should consult with one another if you're okay with that. All right, proceed.
So that
It's okay.
30 seconds rather than 3 minutes is that the striping is not a character-defining feature. I would not have expected to be a C of A issue, and as a standard of practice, I wanted to point out that the National Register program excludes parked areas and particularly parking lots from a consideration of being eligible for the National Register. Thank you very much.
Thank you. Gary Berkowitz, followed by Wendy Kruger.
Hi, Gary Berkowitz. I live in the El Palazzo. I wanted to just clear up something. The building was built in 1931, not in the 20s. The garage had faint stripes, but they were there. Each space was numbered. Everyone parked in the same space every day. Also, cars in 1931, because I Googled it, were huge. They were huge touring cars that people drove. There is no way that they could have fit into these tiny spaces. Got to tell you. How much time do I have? 3 minutes?
I'm sorry, we've been having some issues with the timer. It's hard to see. You have 2 minutes and 22 seconds left.
Okay. I believe that the El Palazzo, I'm going to read it, has had historically 13 spaces. Christina Management would agree that the El Palazzo was originally designed with 18 spaces. Then how do we account for the fact that it has 13 spaces now? This means that at some point in the past, a former owner deliberately reduced the amount of spaces from 18 to 13. I find that nearly impossible to believe. Why would he do it? The only reason that came to mind is that the 18 spaces were untenable. They were too small. Also, a Nathan Galler was the owner of the El Palazzo between the years 1985 and 1995. He wrote a letter to the community development director confirming that the garage did not have 18 spaces when he bought it. I want to point out that most historic buildings of West Hollywood do not offer enough parking spaces to accommodate all of the tenants in the immediate area. They just were not designed that way in and around 1930. I know this because I have, in my 40 years living in West Hollywood, either lived in these buildings or looked to lease the buildings. Oh, excuse me. These buildings include that do not have enough spaces: the El Mirador, the Villa d'Este, the La Fontaine, the Four Gables, the Patio del Moro, the Savoy. They're all within a mile of this building. Believe me, the rents they command are not compromised by the fact that some tenants must park on the street. The people have been parking on the street for close to 90 years. Also, in the years living in West Hollywood, I haven't heard of a single incident whereby a tenant was injured while parking his car on the street. When I leased my apartment 8 years ago, it came with a comfortable parking space. I most likely would not have rented the apartment if I was offered the space that I have now. It is literally half the size it was originally. The spaces have literally been subdivided. Also, in that film they showed you, they didn't show you the row of cars and columns behind where they parked, behind where they backed up. So I find that when I'm trying to back out of my space and I'm in between a car and a column, I have to back out straight and carefully. There are times when I literally get boxed in between the two columns, and I'm not sure what to do. It takes sometimes 10, 12 turns to get out of there. There's also a tenant, her name is Kylie.
Just a note, you are over time. I'm going to let you
I am?
finish because you
All
are
right.
a tenant of the building, and again, I gave the appellant time, but please wrap it up.
She parks between Randy and I, and we're both between columns. She intended to park there. She decided it was not worth squeezing in between us, so she is now parking in the Lotus, which is a sister building owned by the same people, and she incidentally is paying a high fee to do that.
Mr. Berkowitz, what kind of car do you drive?
I drive a Mercedes E300.
Thanks.
And it's very difficult.
Thank you. Wendy Kruger?
Wendy Kruger, resident of El Palacio. I am resident of West Hollywood. This is just simply to urge you to uphold the conclusions of the Director of Community Development regarding the COA. I have been a tenant of El Palacio since April of 1995, at which time, when I moved in, my parking space was designated by a stencil of H2, because that's my unit, and I'm still parking in the same place since 1995. My parking space is actually number 17, which was in the video, and also I know I included a photograph of, in my letter. I think this is more than an inconvenience than the ownership, as the ownership points out. I think that there is a threat to the security of my car and the removal of a housing service that's protected by municipal code. For the management to say that dings happen anywhere is absolutely no comfort to me at all. It doesn't mean that I have to put my car in a situation in which they could occur in a more frequent manner. My Volkswagen Golf happens to be only compact car in the entire garage, and spot 17 is 6 feet 11 inches wide, contrary to what they're saying in their packet of information, because I have a column in there, so I have to do a 3-point turn and back into the space. The only reason I back into it is so I can open up the door to get out. There have been instances where people have parked between myself and another neighbor. I have no idea how they got out of the car. It would appear that they got out of their car through the hatchback, and I'm not getting out of my car through the hatchback. I can, maybe this is the time I, call that, senior citizens card, but this gal is not getting out through the hatchback. They also talk about the safety, and they're concerned about accidents on Fountain Avenue. There's nothing to substantiate accidents, car accidents, pedestrian accidents on Fountain Avenue. In 2014, which is the latest information, there were only 16 pedestrian accidents, all of West Hollywood. 1.7 of them happened on Fountain Avenue, but that could have been in La Cienega, it could have been on La Brea. I don't believe for a second that this management is worried about our safety. If that were the case, they would have better lighting in the staircase, and the garden area. They would repair the entry door 3 times this year. My entry door, which is a secure door, didn't work. And they would investigate the rodent population, which seems to be growing in the courtyard. In 1995, there were 13 spaces, and everyone else parked on the street. So 5 people didn't park on the street, and that seemed to be fine. Nate Goller had no problem renting the apartments without a parking space. If Chateau Park, if this management, Christiana Development, has greedily included parking spaces in each of the new tenant leases, and they now can't fulfill that promises because it's impossible to park in those narrow spaces. It's impossible. I guess they have to only take applications from people who have smart cars, because that's the only kind of car that can fit in there. That's it. Thank you very much.
Thank you.
Oh, sorry, any questions?
I don't think so. Thank you, though. We may call you back up, so be prepared. All right. So I'm going to close. We don't have any more public speakers, David, do we? I'm going to close the public comment portion of the hearing, and we're going to move into...
But we still have the applicant's rebuttal.
Sorry, what's left of it.
Appellant.
David, can you, for the record, state how much time the appellant has left for rebuttal?
2 minutes, 30 seconds.
Okay, thank you. Yeah.
Hi, Ben Resnick again for the appellant. I apologize for not understanding your rules. It's my first time before your commission in many, many years. Last time I appeared, we were in the other building. So here's what I want to say in rebuttal. In our letter that we submitted February 13th, which was part of the appeal, we gave you a footnote, we cited an article, gave you the link. And the article is Pedestrian Killed Yesterday, West Hollywood, Fountain Avenue. That's my bias. Forcing this owner to take away 5 spaces forces 5 tenants to give up spaces. Even if they can find off-site parking and rent it or find it, they have to walk through that. It is a dangerous area. You know that area of Fountain and La Cienega. You know what it's like. It's a thoroughfare. So it makes, public policy-wise, why would we put people at risk? With the director's decision here, he's telling us 5 people have to be on the street. I just find that, I don't know, I can't understand that. There's a false premise placed before you, and that is it's 13 versus 18. That's not the criteria. It's not the criteria, because the 13 was voluntary. That's the way a prior owner may have wanted to operate because he didn't have a full building. That was his choice. This owner decides he wants everyone to have a space. Now, with respect to the rent stabilization, it is an important document. In 1985, which I believe is when the city, if I recall, cityhood was 1984. So people with buildings had to register. So this building was registered. You have the packet that we submitted in 1985 by the then owner, Pamela Mason, who had to sign an application under penalty of perjury, which is right in your application, in which she designates the rent, the units occupied, security deposit, and then all the amenities. And for each unit under parking, it's X'd in, yes, yes, yes. So prior owner in 1985, under penalty of perjury, submitted an application to register the building and showed that there were all had parking spaces. Now, physically, whether everybody was parking at the time or not, I don't know. The building was in better shape then, I'll tell you that. There was one vacancy, as you can see from the rent stabilization. Unfortunately, the subsequent owner let this building rot. And so...
Your time is up.
Thank you.
Okay. Now, we will move into deliberation, but I am going to keep the public hearing open should anyone on the commission have questions for anyone who spoke to us this evening so far. So, who would like to start?
Well, I have a question for our legal. Excuse me? Didn't take a speaker slip.
Did you fill out a speaker slip? Okay. I suppose you can, I would like to allow you to comment. So please give your speaker slip to, I will reopen the public comment portion of the hearing for you. Please go ahead and give your speaker slip to our secretary. Please come up to the podium, state your name and city of residence, sir. You'll have 3 minutes.
Can fill that out after, maybe.
Did he fill it out? Oh, you're filling it out now. I didn't realize you hadn't filled it out.
Is that a problem?
You can, no, it's fine.
My name is Glenn Barenbeim.
Please speak into the microphone, sorry. Thank you.
My name is Glenn Barenbeim, and I've lived in the Palacio since 1996. And I'd like to convey, for some of us who have lived in the building and who deeply love to be there, the fact that Marilyn Monroe lived in my back bedroom, the fact that Stella Adler, the great acting teacher of Brando, lived in my unit, and I happened to have written a documentary about Miss Adler, and I just suddenly discovered her ghost was there. I mean, all of these things have, to some of us, enormous meaning. And the concept of historical authenticity, which seems to change definition based on when it's being used, is, I think, for our landlord as well as for the tenants, a deep frustration. I've passed out some pages, which you can follow if you'd like. But several years ago, when the restriping was taking place, the landlord took the opportunity, although it wasn't part of the permit issued or it wasn't listed as one of the activities, he removed a tandem space that had belonged to me since I first started renting. And although I had been assured this wouldn't happen, it did in fact happen. And I went to the city of West Hollywood and I filed an appeal and went through a very difficult process in which the city decided in my favor and said that the space should be returned to me. Unfortunately, the only recourse I had was to accept a small rent reduction. I'm in the midst of dealing with a cancer diagnosis. I must say that every time I have to make another appearance having to do with tenant-landlord issues, I end up feeling not so well about it. But we had received a notice saying that, from the landlord, saying that to preserve the architectural design of the building, they've restored the configuration of parking lot striping to 18 stalls. And when Eugene Alper from the city came out to check on code compliance, he wrote that indeed, because there were 18 original spaces, the landlord was able to restripe like this. In fact, there were never 18 spaces. There's no proof of this. When I first went to see Mr. Castillo, who had issued the permit, I said, "Where's the plan for the original 18 spaces?" Well, that didn't exist. And in the papers that my landlord filed, he says, "Well, we don't actually have those."
Please continue. Just wrap it up as quickly as you can. Thank you.
Thank you. We don't actually have those papers. So I know that I can explain what the situation is, and that is that it's always been historically the case that the on-site manager has not been given a parking space. There are also 2 additional small units which were maids' quarters, service quarters back in the 30s, which have not been occupied for years, but are being counted in the 18 spaces. In fact, the fact of the matter is that there are 14 rentable units, one of which, because it was the on-site manager, he didn't get a space, and there are 2 units which haven't been occupied for years. And that's how the 18 spaces even, came into play. Indeed, for the 13 rentable units, other than the resident managers, who's never had a space in the garage, until the current one, who actually has 3 cars, and 2 of them are usually parked there. And I don't fault him for this. I'm just saying that this is how those numbers came about. When the hearing officer issued a ruling in my favor, the landlord filed an appeal, which he eventually
Sir, I do need you to wrap it up as soon as possible. Like, you're well out of time. Please continue, but please wrap it up.
I would just like to point out that the argument that was used when my tandem space was removed, which is apparently illegal according to the ordinance on the first page, says the area referred to by Berenbaum as his tandem space could never be used for parking vehicle. The specific area of the covered parking facility is bifurcated by a structural steel and concrete column and cannot be used for parking. Now, there are 6 columns that are in the 18-space plan bifurcated in order to accommodate those 18 spaces. The landlord goes on and says, state law requires landlords to exercise due diligence and to act reasonably to protect occupants. It would constitute negligence on the part of the current landlord to allow the vehicle into the area of the covered parking facility that could damage a structural steel and concrete column and force a collapse of the structure. This would endanger lives and cause significant damages. Now, this is opposite to the filing that was made 2 days ago, in which the claim was that there is no issue about safety, that it's not a problem. you know, this is the argument that was made 2 years ago when it was effective to say, don't give him his space. It will cause deep structural damage because of these columns, and it's these very columns that are, yeah. Thank you, thank you.
Thank you. I have a quick question for you.
Yes.
So to be clear, do you currently have 2 parking spaces?
No, I have one space.
1 space as per the old striping or 1 space as per the new striping?
One space is per the new striping.
Okay, thank you. Any other questions for the?
Yeah. You mentioned there used to be a manager's unit that was converted to a rentable?
No, I'm saying that an on-site resident manager has always had one of the apartments in the building, and
Yeah.
he has never been given a parking space. The
You
resident,
mentioned another one also.
sorry?
Did you mention 2 that didn't have parking spaces?
There are 2 additional closets. One is a basement that flooded years ago that I have no knowledge of having been used for a very long time, and the other, last time I saw it, was being used as the on-site repair person to store excess lumber and plumbing supplies. There's no windows in it.
And they've been converted to 1-bedrooms?
No, they have not been converted to anything. I'm just saying that in order to come up with 18 units, there are 18 spaces with a front door, but only 16 of them have been rentable since I have been in the building since 1996.
Okay.
Really quickly, what kind of car do you drive?
Drive a Kia Optima.
Thank you.
Although I must say, it's, you know, it's the equivalent of if you've bought an airline ticket and you discover the airline has oversold and they tell you that they want to measure everyone's backsides because you might not require a full airplane seat.
Thank you. Any other questions for this resident? Okay, we're in a little bit of a unique situation here because generally speaking, the rebuttal would come following all of the public comment. But in this case, we had a short rebuttal that was followed by public comment. So I'm going to look to the city attorney here. How should we best handle this to do our due diligence to be as fair as possible to all parties?
Sure, I asked Mr. Resnick if he wanted another 30 seconds to rebut. No? Okay.
No, we will likely have questions for you based on some of that comment, but as long as you're okay
I would like to ask a question of Mr. Resnick.
Okay, well, we can move into that now, as I'm going to, again, fully close the public comment portion of this hearing. Speak now or forever hold your peace. And we will move into deliberation, but I'm going to keep the public hearing open so that if we need to have a dialogue with any of the appellant's representatives or the appellants, that we can speak to them. So, Commissioner Buckner, with that being said.
This last speaker brought up an issue that I'm confused about because my understanding was that there were 18 rentable units that required 18 spaces of parking based upon your argument. And so, in fact, do we have 2 units that are non-conforming and not able to be rented? Because normally in the city of West Hollywood, in order to rent it, you have to have a space. But this is a historical building, and so a lot of the rules don't apply. So do we actually have 18 rentable units, or are you fully rented? With the number
The answer
that you-
is we have 18 legally habitable units that can be occupied. Right now, 16 are occupied. I think Mr. Birnbaum was referring to some non-habitable type space where there's storage going on. He said no windows and closed. Those aren't habitable spaces. You know, it's not a legally
So then there's
habitable.
probably 18 spaces that are there, but only 16 of them are...
No. What he was referring to were not part of the 18 units. Go ahead.
So there.
State your name.
Oh, sorry. Lloyd Hussey. There are 18 rentable apartments, and state law requires the resident manager to live on the property, and he occupies one of the units.
One of the 18 units?
One of the 18 units, yeah.
So then...
There may have been a unit many years ago in the basement, in a utility room. We've seen a toilet bowl down there bolted to the floor. It looks like it may have been part of a, that's all that's left of it. It's near the, near a utility space, but it's not an apartment. It's not part of the building anymore. There are 18 rentable apartments in the building.
And the manager lives in one of them?
The manager lives in one of them. That's correct.
Historically, the manager wouldn't have a parking space.
That's not true. It's up to the discretion of the owner whether or not the manager gets a parking spot. In our case, we converted a tenant to manager. He already had a parking space.
Okay.
I think what he's asking is, did the manager historically have one? As to whether or not it's to your discretion, it doesn't really matter. It's not germane to our conversation. I think we're just asking, did the previous manager have a parking space?
The manager during our ownership of the building has always been assigned parking.
Okay.
Yeah.
But he's on site, living there.
Sure.
So he can be a manager, but he's a tenant too.
Sure, I'm also the on-site manager for my building, so it's...
Of course.
A question for staff. Is it true that state demands that there be a manager on site, living on site?
For certain.
Rent
16 or over?
does.
Okay.
Under the rent stabilization ordinance, if there are a certain number of units, I believe that is 16 or more, there needs to be an on-site resident manager.
Thanks.
Sure, Commissioner McGarner, go ahead.
So the applicant stated that there were 6 maybe renters upon purchase, correct?
No, I think he said there were maybe about 8 or so that were vacant. So I think we had about 10 tenants is that about right? It's about right, yeah. About 10 tenants that were in occupation in 2014. So it would have been about 8 vacancies.
Okay. I'm not sure what you were referring to earlier when you said 6, but okay. So
I may have said 6 to 8 because we didn't have that locked in, that number, when you asked.
Okay. So of the 10 tenants who were in residence in 2014 when this is purchased, how many were still in residence with their assigned parking spaces when this restriping occurred?
Okay. Did you hear the question? Were they all having parking spaces?
To my
10?
knowledge, yeah, to my knowledge they did.
So why don't you state that?
So how many people had leases with assigned spaces in 2014 when you purchased it and had assigned spaces when you restriped?
I don't recall the exact numbers. I joined the company in 2015, but I believe that the majority of the tenants that were tenants when we bought the building had parking in the garage. And what was the second part of your question?
And then how many leases did you sign between the day you purchased and the day you restriped where you had assigned parking?
We've had some of the units that we renovated already turn, so that I'd have to think about that, but it's probably a half a dozen or more. So we've got 16 occupied units now, and a couple of those 6 have turned once or twice.
Let me try to answer the commissioner's question more directly. So they bought it in 2014 as some tenants left, work was done on units, and then they were released. So the number is kind of a moving target all the time. But from the time they bought it in 2014, by 2015, they did this work. Because it wasn't until a year later, in 2016, that they had to then do the dimensions and show staff that what the sizes are and what have you. So there was not a lot of time in between there, but there was a turnover going on, and that's why we can't give you an exact count.
I guess my point would be I believe it was Polly's statement that she rented in the past 6 months, fully knowing that she had this skinny little space,
Yes.
and her smart car could fit in there just fine. But the people who rented prior to that had an agreement with a space
Right.
that was assigned.
Right.
And to the rent stabilization code, if I read this correctly and legal can correct me, those downsizing of spaces were a downsizing in their agreed upon space. And so my question is, how many of those people are still in the building and are now parking in a downsized space from what they were originally entitled to in their original lease?
I see, okay. So in the lease, even if they get a space, it doesn't guarantee a size space. It says you get a space.
And it's not assigned space?
No, not assigned, size. You don't get a particular dimension space. The lease doesn't say your space will be 8 by, 20. It doesn't say that. You get a space.
Or a numbered space, like your space number 5.
Yes, that it could say, yes,
So your
but it won't
space-
give you that.
Okay.
The rent control part, though, is, so, I think I understand your question now. So to the extent existing tenants, let's say who had a larger car, now found themselves in a smaller space. Well, no one filed with rent stabilization except Mr. Birnbaum. And the reason he did, as he said correctly, he had a tandem space. And he was unhappy that he was given now one space, not two. He said, oh, I should be entitled to the tandem. And the stabilization board agreed with him and said, yeah, that's a reduction in services. Instead of 2 spaces, you get 1. Okay. But in terms of the spaces being slightly reduced in size, no one's applied for that. No one asked for reduction. They had their space. So I'm assuming now, and I don't have the specific facts for you, that the people's cars and sizes were all moved around and fit where they could fit, because no one was left without a space.
Okay, so I guess I'm a little confused, because we do have 2 tenants here who've been here since 96, et cetera.
Right?
And they're clearly unhappy.
Correct.
But did not file. Can we speak to them to understand?
Right.
Were you aware of this process? I guess Wendy and Gary? Can you come to the?
I need to,
Not completely aware of the details, but I was told that in the event that you have a space taken away or the space is drastically reduced, you can get monetary compensation. But I found that the monetary compensation was very small. What I wanted was my space back, not $100 a month. They're not equivalent.
Okay.
That's why I didn't do it.
sure. I
Thank
need a
you.
note for the record. I'm going to reopen the public comment period, just so we can have, Lauren, is that your recommendation? So that we
Yes,
can
if
have
you-
a
if you're asking
dialogue?
questions
Okay.
of members of the
I'm
public who
reopening it
testified.
as per the last speaker. Commissioner Hoopengarner, do you have additional questions?
That was my point, is about understanding the existing contracts in place with the existing renters and the existing space that they thought they had, which was then downsized kind of with the stroke of a pen. So I wanted to understand how many of those are there, how many of them still exist in the building? And, frankly, I'll go to my little comment, which is maybe those renters should be given priority to the good spaces. I don't know.
That leads into my question, actually. Oh, sorry, Commissioner Bath. So I want to be clear on the number right now. To the appellant, if you could please come to the podium. How many parking spaces are currently open in the garage at the building? Is it 2?
By open, you mean unused right now?
Correct.
I believe we have three vacant stalls. I'm not 100% sure, but I believe that's the
3
case.
vacant stalls.
Yeah.
And you said that does the on-site manager, and I only reference this because it's the only point of reference that I had, it was from one of the public comments. Is the on-site manager using 2 spaces right now, or 1?
He has one assigned spot, and he occasionally parks basically a subcompact car in one of the unassigned spaces, which is unassigned. It's one of the smallest spaces in the building. There's actually a letter from him and a picture that shows the 2 cars together.
Okay. So let me ask you this. Have you ever worked with the existing tenants to maybe get another space that would be better for them? I mean, I understand that they're small, but you know, I mean, Ms. Kruger had noted that her space is so small. I mean, has accommodation been made for some of the tenants who have been there for a long time to maybe get them into a more suitable parking space? Just wondering if this could have not, you know, been worked out just as a kind of gentleman's agreement, if you will.
Yeah, I've had discussions with a number of the tenants, and I'm in discussion right now with one tenant in Unit I-2 who's expressed an interest in potentially switching with another tenant.
Is that tenant here tonight?
He is not,
Okay.
no.
Okay.
So, yeah, we've had conversations.
But have
I
you
don't
had
know
any?
that our client
sorry.
has necessarily given priority to older existing tenants who were there pre the restriping, but I think the criteria, as I was told or was understand, had to do with size of cars and who would fit best where for maneuverability. It wasn't about convenience. So just because somebody may have wanted, hey, I want my old large space back, we have to look at the good of the entire enterprise and the whole building and all 18 people using it. And that's the standard being applied today.
Sure. But we also want you to honor your existing agreement. So currently, there are 3 tenants in the
we are
building who
honoring.
were there prior to the restriping.
We are honoring our existing agreements. The existing agreements do not provide or require a certain size
Size of space.
of
I
a
understand.
space.
I understand that.
And
I understand that.
you have
But
to- yeah.
there are 3 tenants there are 3 tenants in the building who were there, who had parking spaces prior to the restriping?
No, there are more than that. I don't know the exact count. I would estimate 7.
Okay, let me ask
Yeah.
you this. Are there any tenants in the building right now? I hope that you have this information. Are there any tenants in the building right now who were there prior to the restriping who didn't have a parking space before? And who now do as per the restriping?
No.
Okay. Those are my questions, at least for right now.
And back to be clear, the existing leases with the existing tenants had a referenced parking space by number, which by definition had a size per your diagram of the existing, wherever it is, there's too many pages in here. You had a diagram of the previous,
We did not submit any diagrams or have ones of the
so
previous.
in this diagram that is in Exhibit 10B,
Right.
excuse me, Exhibit C, page 1, it's only 1 page. This is the diagram of the previous layout of the parking. And
Okay.
so
this is not our diagram. Well, I'm sorry, I'll wait for the question.
I'll let staff tell us where this diagram came from.
I can tell you, and then I guess staff could confirm. Prior owner applied to the city to change this from an apartment building to a,
Condominium?
no, a bed and breakfast. And submitted as part of the application it was going to be a bed and breakfast kind of a facility. That's where this comes from, and then it died. The application never went anywhere.
Okay.
We
So-
didn't do this.
So I guess my first question would be to the tenants who've been there for decades, is this diagram, does this in fact represent the striping that has been in place since you've been a resident since 1996, however, whenever it was? So
I mean, have they seen this?
it's what's in the package.
Sure, but I don't
Yeah.
assume that everybody here tonight has had time to review the packet. I just want to be clear. If you need to take a look at it, please come up to the dais and take a look.
So it's to be clear to the viewers at home, this is Exhibit C.
I'm sorry, you can explain to them. Oh, sorry, I'll hold it.
Yes, Exhibit C is correct, except for 9 and 10, those were straight. That weren't angled like that.
So it's not correct.
So it's not correct.
Okay.
I mean, there just were 2 spaces there, but the line would have been straight. Were
Okay.
Parallel parked, yeah.
So in short then, to the size of the spaces, these would be correct dimensions?
Yes.
Okay. And so in your lease, you had an assignment to a space by number.
Number 2.
Number 2. So you were number 2, and you had a space of this size for 2 decades.
Yes.
Okay. And so the owner, upon restriping, reassigned you number 2.
No, I'm number 17 now.
Oh, so you're no longer, so you have a new number.
New number.
So it is not the same number as on your lease, to Mr. Resnick's point that the tenant is guaranteed a space, just not by size, but the lease points to space number 2, but you no longer have space number 2.
That's correct.
And space number 2 on the new diagram, I don't think we have space numbers on the new diagram. So can you point us to where you're now parking in space number 2? Because the applicant gave us this map, and it doesn't have space numbers on it, so I don't know where space number 2 is.
It's S, it's just referred to as.
They're all, that's just.
Means subcompact.
Subcompact.
It says 7 foot 8 inches, but that includes the width of the pole, so.
Well, that I understand, but just which space is it? Is it even near where you used to park?
Yes, it's the exact same space, it's this one.
So-
There were 2 spaces here, there are now 3 spaces here.
So when you come in the driveway, turn left, 1, 2, 3, that's now space number 17, but that's your space.
Correct.
Okay, so it's in the same general geography, but just resized and renumbered.
Correct.
Okay.
But have we confirmed that the leases for all of the tenants who were there prior to the restriping have assigned spaces next to them? And is there, I should also ask, a provision just in terms of what a landlord is able to do as long as the parking is still being provided? Is that still in compliance with the terms of the lease? I mean, again, these are questions that I just want to make sure I understand, because I don't want to get, like, drilled down too much. We need to consider this under a certain set of terms and findings, and I want to be sure that we're structuring the conversation to that end.
Yeah, I think you're trying to understand the changes.
Correct.
The scope of the changes.
And I don't want to get into rent stabilization's bailiwick, but this does tie into it, and I think, we're trying to make a planning decision, but there's implications, obviously.
Yes. So 2 points, if I may, on that, Commissioner. The exhibit you pointed to, the 13-spot exhibit, which has angular spaces, which we now know from the tenants was wrong, but like I said, it was submitted for a bed and breakfast. You remember Mr. Birnbaum said he had tandem spaces. They don't appear on this. And the reason they don't appear on this is not necessarily accurate. He had a tandem space, and he got a rent reduction when we took that away. So Exhibit C is not a basis upon which I think anyone can decide and determine that is what was on the ground at the time. There were places. Again, the building was very old, worn out, the lines were worn out, and, people kind of moved around. And so I just want to point out, Exhibit C is not accurate at all for many reasons. Secondly, on the question of rent control, we gave you an email, or I think you saw it from Mr. Castillo, back in 2015, when he visited the site, talked to our client about the certificate of appropriateness. In his email, he says, and by the way, the reduction in these sizes of spaces may trigger rent stabilization, rent reduction. You should know that. So that email is in the record. Staff knew it. We knew it. It was raised.
Okay, we're only talking about what's in the staff report right now, so I don't want to,
In the staff report. Yeah, the email? Oh, you mean the...
Well, you said that there was something that's not in the staff report.
Yeah.
We're only here to discuss items that were contained in the staff report.
I see. So that email from Mr. Castillo and the response from our client, Mr. Taylor, is in our rebuttal letter. We attached it. So it's in your record. And we showed it because we wanted to show you this was a collaborative process, and the notion that we have to deal with potential rent stabilization, we knew and was raised and discussed.
Okay, does that answer your question?
I'm sorry, I need to jump in and correct the record for a moment.
Sure, please do.
It wasn't a tandem space that he had. If you look again at Exhibit C, he was parking in the corner. If you can look He had space number 8, and then he was parking in that corner. That was his second space.
He said the word tandem, which is why I'm
Well,
repeating. I
that's an
assume he
incorrect
knew what he
use of
said.
that word.
It's not a true tandem space in the sense that it's not front to back, and I'm assuming that's per our code, the definition of a tandem space.
Correct.
So
The
he
way
had-
that he was using it was that one car would have to pull out to let the other out, but it's not a true tandem. Okay, thank you.
Thank you, because that was my confusion. So in effect, then, to Ms. Kruger's point, this is the diagram without the exception of the straightening of spaces 9 and 10. And he was simply parking in that vacant corner. Since he had that space number 8, he could squeeze 2 cars in there.
Correct. And that configuration was verified by Mr. Castillo's independent inspection on the ground.
Okay, thank you. That clarifies that.
Any other questions for the applicant?
I
at
have
this
one
time?
for staff that may or may not lead to one for the applicant, I'm not sure.
Okay, go ahead.
Help me understand non-conforming standards for these historic buildings. Specifically, the applicant is telling us that we really can't govern their parking. My understanding, and again, I come at this without any legal training at all, but my understanding is that it basically, like there's a snapshot in time, like when we become a city or at a certain point at which whatever conditions they have at that moment, which would have been parking, are appropriate. But if they change it from that, then at that point in time, the city has some jurisdiction. Help me understand that a little bit.
I think that's a pretty good understanding of the nonconforming ordinance. It's not that if you were built before cityhood, the rules never apply to you. I think that's sort of a misstatement of the rule. It's that it wouldn't be fair to apply brand-new rules to very old buildings so they get to maintain the status quo that they have from before the new rule, and if they want to expand or change in some way, then there's an opportunity to make them come into compliance with new rules. So that's a statement of nonconforming generally. This one is a little bit challenging because the building is so old, and I think the question that everyone's trying to understand tonight is what was the original condition? That is there's evidence on both sides. Was it originally 13? Was it originally 18? So everyone's trying to work out what is the condition they're required to stay at, and then if they change.
So a follow-up. The 1985 document shows that there were 18 spots. That seems very clear to me.
Yeah.
But
I'm gonna let staff address that, but finish
let me
your
follow up
question.
with my
Yeah.
question. But all the evidence that we just had a very lengthy conversation, and it was confirmed by Mr. Castillo's visit, was that there were 13 spots when they submitted this application. So with non-conforming status, even if it was in 1985, it was 18. Let's just, for the purpose of this question only, assume that that's accurate, that there were 18 spots at that point in time. At some point between 1985 and Mr. Castillo's visit, or 1996 when these folks moved in, it was reduced to 13. Mm-hmm. At what point does non-conforming go into effect? Does it go into effect in 1985 because that was their maximum, or does it go into effect at the point they applied for this COA, at which point it was 13?
Or does it go into effect at the time it was designated an historical building?
I don't think it goes into effect when it was designated historic.
Where's that snapshot in time is what I'm trying to understand.
Right.
And I would like an opportunity to comment on that. If
I do have a follow-up for you,
Yeah.
and just to keep with this whole train of thought
Right.
once I get this answer.
The evidence that the city has in its record is that there were 13 spaces. That's what the existing floor plans show. That's what the records from the property owner from the 80s show. So that's what the evidence that the city has been relying on shows, that for many years it operated with 13. So if that were to change, I think it would be appropriate to say that the new parking rules would apply. There's parking rules with respect to number, and there's parking rules with respect to size. So at some point, if they start changing the parking, new parking spaces should meet new standards. And that's with respect to width, depth, all these things that we now have in our code. It's not to say because the building is historic, we can never apply what are generally applicable parking standards for all buildings now in in our code. So
I just really on that, because I have a whole, I want to get to a point here with ultimately a question for the applicant, and that is, I want to also, you said that all the evidence that we have, I want to just highlight for the record that the entire conversation we had just prior to me asking this question in response to Commissioner Hoopengarner's questions, the applicants, or the appellants themselves even acknowledged that there were 13 spots in that conversation. So the evidence presented here tonight in this conversation identifies that there were 13 spots in the conversation right there. So my question is, bringing to you, why the COA if you're not required to get one? Why did you ask for it in the COA if you weren't required to get it?
That's a good question, Commissioner. So the person who filled out the certificate of appropriateness application had work that was the subject of an appropriate C of A. There were fixtures being changed. There were certain other things done within the garage that did require that. It was, I would say, an over-inclusive application. If you look at the 5 items they listed in there, the last one being, oh, by the way, I'm going to restripe the garage to 18.
The oh, by the way, is something you're adding now. It's not on the document. Okay. No, the flippant oh, by the way isn't on there. It's the...
Item 5 in the application. Item 5 in the certificate of appropriate application says we're going to restripe. But if you look the first few items before that, they were appropriate subject of that. And your own code, when it comes to the certificate, have it right here. Give me just 1 second. So section 19.58.090, certificates of appropriateness is the section. It's required for alteration, demolition, and removal of individual cultural resource or contributing cultural resource, etc. Alteration is defined as basically changes to the specified character defining or significant physical features of an architectural appearance of a cultural resource. So the application for the certificate of occupancy filed in 2015, signed by the then manager of the building, says we're going to do remove fluorescent tubing, lighting fixtures. That clearly requires a certificate of appropriateness.
So what you're saying is that the certificate of appropriateness included the parking, but was not limited to the parking. It was required for other renovations that needed to be made to the garage.
Yeah. So item 3 is replace lighting with period correct fixtures.
There are 5 items on there. I'm looking at it.
So and then when they threw in the the striping for 18 spaces, it says as originally designed and city registered. Okay, put that in. I'm just maintaining. And as soon as I saw it, I realized that. A certificate of appropriateness is not required when you're painting parking spaces, okay? So he threw it in there to be kind of all-inclusive. Again, they did everything with certificates of appropriateness, followed all the rules. I think this was an overly broad application. Now, the snapshot, and this is really key to our entire case, because I think you're asking the right question. The snapshot is not at any one point in time because it may have changed. Different owners, different operators, different levels of occupancy. Sometimes you had more cars or less cars. The snapshot is when this building got its certificate of occupancy, when it became legal. 1931, 1932, when it was constructed and completed. The snapshot is this is a building with 18 legal units and no required parking. That was the law. The parking that was built and provided was to try to get more rent, to be able to have a nicer building, to attract more tenants, but it was voluntary. It was not regulated. That's the snapshot. And by the way, the city attorney's right. The fact that it's historic is irrelevant to the question of legal nonconforming rights, because even buildings that are not historical, if they were built legally and a city subsequently changes the rules, you can't force them to go back and change it. That's why they're legal.
But if you were to renovate it in any way, you would have to bring it up to all the pertinent codes, correct?
So the renovation here is, it's only if you're expanding the uses, that's when you lose legal nonconforming status. The uses are not expanded. It's an 18-unit apartment building. The envelope is the same. The frame is the same. Everything remained the same.
Excuse me, sorry,
I
city
believe our
attorney.
legal has.
Yeah.
some
Well,
reason.
I just want to make one point about the point at time which the building becomes non-conforming. It becomes non-conforming when the new code is adopted.
right.
So either at cityhood or when the zoning ordinance was adopted, whatever that exact period in time when the rules, the parking rules went into effect, that would be the period in time where it became non-conforming because it no longer complies with your new code. That's what non-conforming is. It's not a free pass for rules indefinitely. It's saying you don't have to comply with this new rule until you expand or something happens. So it's the period of time that the new ordinance went into effect that triggers what your existing condition was.
But if
And
this-
that, and it can't be made more non-conforming after that point. Eventually, we want you to come into conformance, but you have some time to do it. It wouldn't be fair to require you to do it immediately. That's the non-conforming theory.
But there's no way that this could ever be conforming because we don't have the depth.
For the number of spaces, it could still come into conformance with the size we require now for spaces, which is about 9 feet a standard?
But they need to
8
be,
and a half.
but they need to be 18 feet deep, and there's no way that you could really do that in this structure. So I don't think this could ever be conforming.
I guess the theory would be you get more into conformance. You might never be able to meet all of the parking standards that exist today, but we always want to come more towards our rules
Sure.
than farther away from our new rules.
So legal nonconforming,
Yeah.
Every ordinance-
We're in question and answer period here, so we should go back to the
Yeah, I'm gonna like bring this back to
I
Commissioner
thought I was
Bass
still,
because.
I was answering, I'm sorry, I
Yes,
thought I was
the question.
answering the
Commissioner
question.
Bass, do you feel that the appellant has adequately answered your question, or do you want him to continue?
Yeah, I think that answers it. I have another question for staff, but we can move on with others.
Okay, go ahead.
But let me
Commissioner
come
Bass.
back to it, I'm sorry. I just blanked.
I have a question. Does staff, okay, I want to make sure that I'm thinking about this in the right way. And then looking at the somewhat unreadable document. At the time that the application was filed in 1985, was the applicant stating that there were 18 spaces or that there was the capacity for 18 spaces?
Are you referring to the registration form?
Correct.
That was filed? It's unclear. Well, they weren't necessarily referring to the capacity. It's also unclear where that parking was provided. So it could be that they offered parking to the tenant, but it might not have been on site.
It's
So
my
unclear.
understanding that a number of tenants, both today and back in the day, parked next door at the Lotus. So could that have been the reference to the fact that there was available parking for these tenants? It wasn't necessarily in this building.
Sure.
Thank you.
Right, but we don't have anything that's contained in the staff report to support that beyond any testimony we might have heard this evening, correct? I mean, I'm just trying to, we have some evidence here that is in conflict with one another, and I think it's why this makes this so nuanced and multi-layered. So I'm trying to determine, they were just saying that there were 18 of the units had parking, but it wasn't specified where that parking was.
Correct.
Like in the garage, outside of the garage, whatever the case might be.
Right, and my understanding is the Lotus and the Palacio were owned by a single owner at that point, so there could have been other spaces next door.
Okay.
You're right, we do not know.
Okay,
Yeah.
thank you. Go ahead, Sue.
Lauren, can you go back to the findings that you read to us in the beginning? Because I think that, for me, that's where I need to go to with this. Because if we're going to approve the staff report, which would require us to affirm the revocation of the certificate of appropriateness, we have to be able to make those findings, right? So can you say them again so we can focus on that? Because I need to focus there.
Yes. It's in 1980-060 for permit revocation. The circumstances under which a certificate of appropriateness was granted has been changed by the applicant to agree that one or the more findings contained in the original certificate of appropriateness can no longer be made in a positive manner, and that public health, safety, and welfare require the revocation. Or the improvement authorized in compliance with the certificate of appropriateness is in violation of any code, so if this creates a code violation, or the improvement or use allowed by the certificate of appropriateness has become detrimental to the public health, safety, or general welfare, or the manner of operation constitutes or is creating a nuisance as determined by the review authority. So those are the three relevant revocation findings that the commission would need to find in order to revoke the certificate of appropriateness as to the parking striping.
I'm still having a hard time holding on to that.
It's a lot.
Do you have,
the
can I
findings,
see that piece of paper?
Staff prepared some proposed findings which are similar to the proposed findings that the director made after his director's hearing, and those are on they start on page 2 of 7 of the resolution.
Commissioner Buckner's questions actually reminded me of my question. When it comes to public safety and welfare, we have prescribed parking sizes, parking stall sizes for a reason. And I don't believe it is arbitrary. I believe that those are adopted for a reason. Is it possible that we have those for the public safety and welfare of residents, the size of those, or is that something I'm just grasping at? I mean, has the city already adopted and said, we're adopting these parking sizes because that's what's safe for vehicles?
Yes, I think all parking regulations are for safe and efficient operation of parking vehicles
because I think that's what's missing is that
and
maybe,
entering and exiting.
Maybe we're not being very specific on these spots and saying, you can't have this number of spots for, because it's inconvenient to this person or that person. And I'll tell you, if I can offer some comments here, and that is that an ex of mine lives in an old building and he drives a Fiat, and at one point while we were dating, he got his parking spot changed from one side of the parking garage to another because of his Fiat. They said, this new person has a bigger car, they need your spot, you need to move into this other spot. That happens, and he was fine with it because it was easier to move in and out his car than the other person's. So those sorts of things happen, but so the inconvenience factor, although I would hate it myself, I can't see that we can make the findings off of that. But if it truly is the safety and welfare, and I do believe the property maintenance and people's vehicle safety is something that we can consider, not just physical harm to an individual, but people have a certain expectation that their cars aren't going to get banged up when they pull into their parking garage, a certain level of expectation. I park on the street and I expect mine not to get banged up either, but you should see the bumper on my car. So it happens. But so I think that we adopt those sizes for the welfare of our residents in general. And so although some exception will have to be made because of the historic nature of this building, I just don't know that this size is accomplishing that, but I don't know. I'm undecided at this point.
Go ahead.
These issues are quite difficult. As you can see, we're all having difficulty with this. I think that what we've got going on is a conflict in different codes. We say that we should have one parking space per unit is one of the things that we projects that come before our commission, that we have that, and everybody wants standard size spaces, which require a certain amount of space, but we allow tandem spaces and we allow compact tandem and all different ways, even in new buildings that come before this commission. So it's very confusing because there's parking requirements like size of spaces, which we modify all the time. So and then this is non-conforming use, an old building, a historical building. And how is it that it doesn't seem that parking spaces have to do with architectural integrity of a building? So it's, as far as I'm concerned, I'm wondering why we're even dealing with parking. And is that something that really is required, that there be certain amount of parking in an historical building, or that the city even gets involved in that?
Well, we're here because the property owner applied for a certificate of appropriateness and included in that the restriping of the parking spaces.
So he put himself in jeopardy, in a sense, by doing that.
I know that the appellant was arguing that, you know, we shouldn't be dealing with the certificate of appropriateness, but that's what we're dealing with. It may not be a perfect situation. If it was, we probably wouldn't be here. But that's the permit that was issued for this type of activity. And if staff has determined that that activity on the site isn't appropriate, they've taken the action to revoke it. The appellant has appealed that decision. And so that's the type of permit that we're looking at.
So we're also talking about public safety and damage, and there's been evidence provided here at this hearing that there have been nobody's been injured in the parking garage. No cars have been damaged, and I don't know if we can make a finding that there's a problem here for public safety. It's certainly inconvenient, and it's certainly difficult, and I understand the outrage that the tenants that had been there for a long time, but I'm not sure that we can, since we're asking to make some legal findings, that we can actually make those findings to affirm the director's position. I mean, I guess if you want to put it that way. I'm having a hard time making the findings and finding that we can actually, for me, I'm not sure I can actually affirm and do that.
Okay.
Because it doesn't make legal sense. And I see you shaking your head.
Well, I mean, that's the difficult determination that the commission is being asked to make tonight.
But we're supposed to use evidence, and the
That is
only
correct.
evidence, the only document we have is the 1985 document that was filed with rent stabilization. We don't know whether the parking spaces were provided elsewhere or in the building or how they were. It just says that. So it's a legal document. It's a document that we're asked to use as evidence, but it's not really clear what it really meant or what it really provided.
Right, and that's the purpose of a hearing, is to weigh the different evidence and decide which has more value to you to help support your decision. That's the difficult decision that you're asked to make tonight.
But we also have evidence from a living person who purchased the building, who said there were not 18 spaces in the building in 1985. So we have a piece of paper from the city, and we have a letter from a living person, and per my email this afternoon, Tony, you confirm that you actually spoke to this living person, and he confirmed what he submitted in writing, yes?
However, he's not here for us to
Cross-examine, understood. But
Commissioner Caballero, I want to go in order here.
Yeah, I agree with Commissioner Buckner. I think the information provided is inconclusive. And I'm going to throw a different spin on this. I used to live in La Fontaine, and I currently live in Villa d'Este. And we have 11 units in Villa d'Este, and we have 6 parking spaces. The 2-bedroom units are required to rent a parking space from the mall at the corner of Sunset and Crescent Heights. There are many units in La Fontaine that didn't have parking spaces. You either parked on the street, or you also rented units up the street on the corner of Crescent Heights and Sunset. Our spaces are 7'4" wide. I'm very familiar with that parking situation that was presented in the video and that's presented in this diagram. It sucks, but no one's going to die from it. I've stopped wearing white pants, because that's obviously a casualty of, parking within a foot of another car. But I can't see how we can say that there is a dangerous situation being proposed here. And honestly, when I spoke to Ira this morning, I kind of was shocked that we have spent so much money on legal fees and so much time kind of going through this through the last year and a half, I would like to see sort of a resolution to this. What I see as this parking layout, according to my experience at La Fontaine and Villa d'Este, is workable. It is not ideal, but I can't see how we can say that this layout could cause hazard to someone's life. It is inconvenient.
Commissioner Guy.
I have to concur with Commissioners Buckner and Cavallero. I'm not going to reiterate what you guys said, but I agree. The other issue, I mean, the two issues I have is one, the 1985 rent stabilization document that cites that there are 18 spaces. Agreed. We don't know if they were on-site or off-site, but there are 18 that were cited. And the other issue I had is Exhibit 10B, the application, I think it was for the certificate of appropriateness. Item 5, it says 18 vehicles as originally designed. So, yeah, I would not be in favor of I would be in favor of supporting the applicant's appeal, the appellant's appeal.
Commissioner Hoopengarner.
So, to the point of as originally designed, I think we've all agreed we have no blueprints, we have no record of 1930. So the statement on the application of as originally designed, I can't make that finding, that there were 18 spaces in 1930. In addition, having grown up in Michigan and being a little bit of a car buff, the cars that they had in 1930 would have never fit in 18 spaces of any configuration in this building. So to make a statement that there were 18 spaces in this building in the original design, I find to be frankly impossible. There were no cars, unless you did have a Model A or a Model T, but all of the cars in the 1930, remember this was a high-end building, this was marketed as a high-end building, were going to have high-end cars, and those were going to be big cars. We called them boats, because that's what they were. They got gallons to the mile, not miles to the gallon. Again, the finding of the 18 spaces in the 1985 document, personally, I see a document where the owner went, oh, I got to fill out this new form. They went check, check, check down the page. And to my discussions with the renters, they were told, you have parking. It's first come, first served. If you can find a space, you can park, but if you're number 16, you're not going to find parking. And the fact that we have the owner of 10 years who is an experienced landlord, building owner. If I understand, this is the person that owns Phyllis Morris and all of the property that's going to become Robertson Lane. This is a landlord who would have changed the parking to increase parking, could they, because they understand the value of the parking. That said, as far as the findings, safety. I'm going to have a minor disagreement with a couple of my colleagues. If you've ever had a serious bruise from a door swing, and I know of someone who's had an embolism from a serious bruise, and twisting your body to get out of those spaces can cause bodily harm. To speaking to welfare, if you've got to repair your car, that costs money, that affects the welfare of the tenant. If nobody's had any problems in the past 3 years, great. But I do not think that it's a life and death safety issue, but I do believe that there are safety issues in this space. To the second finding in the staff's report, that the dimensions were not accurate, I think that's true. On the owner's application, they're in fact missing. The columns were not drawn to scale, and truly identifying the spaces that would be afforded to these tenants. And finally, I'm still at a quandary about the renters that have leases, that had spaces, who had their space size downsized. And at what point do we say, yes, we have ordinances, but never mind. Yes, we have renter protections. We're the renter city. You know, we are here to protect our renters, and yet to say, oh, but in this case, it's going to help out a couple of other renters, but if you've been paying rent here for 20 years, we can go ahead and downsize your space. I'm not feeling very comfortable with that. So I think this whole process, frankly, could have been managed far better on the part of all parties. My personal preference would be for the parties to come to a table and figure out a way to work this out. Number one, perhaps, would be grandfathering in the existing renters with the better spaces. But that said, I haven't made up my mind yet.
By existing renters, Commissioner Huber-Garner, do you mean the renters who were there pre-striping?
Listing prior to the purchase and restriping.
So I have a question for staff, a procedural question as regards our decision here tonight. Is this we're supporting staff's recommendation or we are not? Is there any middle ground to which we might be able to come? And I'm not alluding to anything because I don't know what that might be, but I'm just wondering in terms of issuing a decision, coming to a vote, what our options are here. Or could we condition it in a certain way, or is it just a yes or no?
There's not really conditioning from a revocation. The
knew you were
only
gonna say
other
that.
option available in the code is a modification to the certificate of appropriateness that has a different set of findings. I think staff would have to do some analysis as to whether they would support, if they would have findings to support a modification, some sort of middle ground, but there is no way to condition a revocation, that you're
Okay,
either
that's what I thought. I
revoking the
just-
permit.
Okay. Can I ask a question of the appellant? Could you please come up to the podium? That you know of, are there any tenants currently living in the building who are not parking in the garage because they cannot park in a space?
Anybody?
I know, but.
So every tenant has a space. I mean, that's just confirmed. Mr. Hussey just confirmed that for me. So
Every tenant of the 16 who are currently inhabiting the building?
Yes,
Okay.
everyone has a space.
Okay.
And are they using the space?
If they're not using a space, they, haven't asked us to pay for anything off-site, and there's no street parking on Fountain that I'm aware of. So I don't know where they'd be parking.
I'd like to,
the two tenants have answers to
I
this
think
question?
without bringing him up, he said earlier that there is a tenant who couldn't fit into the spots. My recollection of his testimony was that he said there was a tenant who can't fit in the spots and rents next door at some cost. Yeah.
Ms.
I
Regan
believe
also
that
has
was what I
something she
heard
wanted
earlier.
to add.
at the director's hearing, there were 5 tenants who testified at the director's hearing who said they're no longer parking in the garage because they can't do so, so they're parking elsewhere. They're being forced to park elsewhere.
And are any of those tenants
However-
here tonight?
I don't know.
However, it's not part of the staff report. We can't consider that
That's
information.
exactly right, and that's
We,
what I
we
mean.
have the minutes from the director's hearing in our staff report, so I would suggest that it is part of our staff report.
But does it say that?
I would need to reread it. I don't recall reading
And that
it.
was also as of February, and I don't know who still lives in the building and who does not.
And we would deny that they can't park there, or that they're not been parking there.
Okay.
Mr. Hussey can provide more
Okay.
insight on that.
Thank you. I think it's important for us to consider what's included in the staff report, and I'm not going to take any further unless there's anyone in the audience here tonight who is currently a resident of El Palacio who is only parking outside of the parking garage because they cannot fit their car in the space. Okay. I'm going to weigh in with where I'm at with this. I've been, just to bird's eye view this and go to 30,000 feet for a minute. When we consider projects and we have public hearings or have a situation like this, which I've personally never had since I've been on commission, the biggest complaints that we get are about parking and traffic. And as anyone who has ever been to the city of West Hollywood knows, these are things that we all deal with on a daily basis. I am a neighbor of Commissioner Cavaliero's. I also live in a legal non-conforming building with there's been some liberty given to some of the spaces. I would also just posit the question, it is a commercial use. Has anyone ever tried to park in the Whole Foods parking lot at Santa Monica and Fairfax? Yeah, exactly. I think what I want to make sure that the message that I deliver this evening from my mind is that we are being fair to all of the people who are currently renting in the building, and recognizing that there are people who have lived there for longer than the past, since the restriping occurred. But on the one hand, I think about, well, if you can't park in a space, then it kind of doesn't matter whether there's a parking space or not. But I also don't want to take viable parking spaces away from people who are actually using them. That corner, which I pass multiple times a day, I think is mostly red zoned. I don't think you can park on that part of Fountain at all. So I tend to be in agreement with Commissioner Buckner and Commissioner Caballero and Commissioner Guy, and that I don't know that I can make the findings to support the findings we need to make to support, revocation of the certificate of appropriateness, thereby upholding the decision made in the director's hearing. I'm struggling with that. Public safety and welfare, I don't know if we have that's a pretty broad term. I mean, if no claims for, personal injury or damage to vehicles have been filed, I find it, hard to believe that there would be reason for us to make a consideration of that. I mean, again, I get that it's an inconvenience, but that's really where I'm at right now. I think I would tend to agree with the commissioners I noted earlier, and I'm open to discussion, but given that this isn't a kind of traditional hearing, this is an appeal hearing, unless someone has a modification they want to propose, I think I would likely vote to not support staff's recommendation at this time.
Mike, could you make a motion, or
Do
we have to close the public hearing?
Do we have any further commissioner comment?
The only thing I can add is that I'm a testament to the fact that you can park in 7'5" parking spaces, because that's how I've lived for the last 3 years. When I lived at La Fontaine, they were even smaller, and we dealt with it. It is possible.
With that, I'm going to make.
Our chair mentioned earlier wanting to find a middle ground. I would love to do that here. I think that I'm going to support the majority on this, because although I think we could make those findings, I think they would just barely be making those findings. So I think that maybe a COA wasn't required here. I think that the comments of the commissioners after I spoke were fairly persuasive, because I really was right on the fence. But I wanted to speak up just because I think that there is, right now, I asked earlier what the count was, and there are 15 spots being used, not 18, currently, from what our calculations were earlier. Maybe there's a way that the landlord could just work with those 15 spots with the people who were there. I know we can't condition it, but I can say it out loud that I wish that they would do that. And with that, I'm going to support the appeal.
And I would concur. I think there's a lot of pieces here that are incomplete at best. But parking is parking. And having an available space, and yes, I would agree with Wendy about having to crawl through the back of your hatchback is not ideal. But I would encourage the landlord to do more than talk, but to actually take some action. This has been going on for 2 years. And to accommodate those that had leases, that had expectations, that under the intent of our rent stabilization guidelines would dictate that those tenants be given priority for the spaces commensurate with the spaces that they had when they signed their leases. I think that this has taken far longer than it ever should have. Thank you.
I'm going to make a motion to grant the appellant's appeal.
So we would have to come back next month with the findings to support that. We would bring a resolution back next month.
Okay, understood.
Motion by
next
Commissioner
meeting.
Guy, seconded by Commissioner Buckner.
All right, let's call the question. To make a note, the public hearing is now closed.
And the motion carries unanimously. Resolution will be brought back.
Yeah.
All right, I think we can, are we okay with just continuing and getting through the rest of our agenda items? Is that okay? All right. Thank you. Please try to keep the noise to a minimum as we're going to continue the meeting. So moving on to item 11, new business, there is none. Item 12, unfinished business, we have none. Item 13, excluded consent calendar, there is none. Item 14, items from staff, 14A, planning manager's update.
None this evening.
Great, thank you, David DeGrazia. Item 15, public comment. Do we have any speakers at this time?
No speakers at this time.
Thank you. Any items from commissioners? Item 16? No. And with that, I will come to item 17, adjournment. Adjourning this meeting, we will adjourn to a regularly scheduled meeting on Thursday, October 4th, beginning at 6:30 p.m. Thank you, everyone, for coming out tonight.